already also started the recording. Just with some probably.
I start.
Sorry?
I started the recording.
Okay,
We are
perfect.
online. Okay.
Good evening, everyone, and welcome to this Apéro du droit. I'm very happy to greet so many of you already. My name is Angelo Marletta. I'm a postdoctoral researcher at the Centre de droit européen of the ULB, and I will share this Apéro entitled "Who is a Smuggler? Rethinking the Criminalization of Migrant Smuggling in Light of the Principle of European Solidarity." Unfortunately, despite our best efforts, we were eventually unable to secure the presence of a member of the European Parliament due to calendar incompatibilities. However, this is not a tragedy, and this will allow us more time to listen and discuss with two excellent speakers, whom I would like to extend my warmest thanks and welcome. The title of this second Apéro du droit opens with a question: who is a smuggler? In recent years, this question has often been raised in connection with investigations and prosecutions against NGOs, volunteers, and ordinary citizens for providing assistance or acting in solidarity with migrants. The cases of the investigation and prosecutions against the volunteers and crews of NGOs ships conducting private search and rescue operations in the Mediterranean, such as you can read at Sea-Watch and Mediterranean, are perhaps the best known cases, not least because of the international media coverage that they have received. We can say that after 2015, in some way in the public debate, the image of rescuers at sea has been transformed, and as some commentators said, has evolved from angels to vice smugglers, deputy smugglers. However, also on land, prosecution of individuals who provided humanitarian assistance to asylum seekers and migrants entering or transiting the territory of the EU member states were not uncommon. In addition to the well-known French cases of the Roya Valley, of Benoit Duclos, and the proceedings against Cédric Caroux, which led to an important decision of the French Conseil Constitutionnel, one can recall the proceedings against the NGOs such as the Center for Peace Studies and Are You Serious in Croatia, or the Procès des Hébergeurs, which has recently resumed in appeal here in Brussels. And although with different features and contours, contributed to the same context also the controversial legislative reforms enacted in Hungary in 2018, for example, with the introduction of Article 353, paragraph A of the Hungarian Criminal Code, which criminalizes anyone who facilitates the opening of an unfunded asylum procedure. And in respect of this provision, we know that there is currently an ongoing infringement proceeding pending before the Court of Justice. Truth be told, the problem of the criminalization of solidarity under smuggling law is not entirely new. And some significant cases, such as the one, for example, involving the ship Capanamur, had already occurred in the past, even before the start of the so-called migration crisis. It is, however, only in the last year, after 2015, that European anti-smuggling legislation has been discussed and has shown a considerable potential for over-criminalization. In particular, I refer to the debate that has been ongoing in the last year on the reform of the so-called facilitator package, which is a body of EU secondary law that since early 2000 has aimed at approximating the national definition of the offenses of facilitation of irregular entry, transit, and residence in the territory of the member states. I will not go into the details of the issues surrounding the facilitator package in order not to overlap with the presentation of our distinguished speakers, but I would like to point out that still today the repeated calls for reform coming from civil society, but also from the European Parliament, have not been followed up by the European legislator. Although some appreciable clarification with respect to the non-possibility to incriminate rescue at sea have been provided by the European Commission in its guidance on the application of the facilitator package, which has been presented in September 2020 in the context of the new pact on migration. Indeed, the issue of the possibility to incriminate conducts inspired by humanitarian reasons or solidarity motives, with the exception of the case of rescue at sea, remains open. In this respect, I would like just to point out that the title of our event also contains a reference to solidarity. There are undoubtedly different ways of understanding the concept of solidarity in political, ethical, moral, and the legal discourse. We can think about solidarity in a general terms as a shared vision of the human struggle that in some way leads towards empathy and some way an exchange, bilateral exchange with the other human beings. But moving on a legal perspective, I would like to recall the words of the Advocate General Sharpstone that has pointed out in his opinion on the so-called relocation cases that solidarity can be considered as the lifeblood of the European project. And starting from these cases, we can see that solidarity seems, the principle of solidarity seems to starting having a form of recognition as a principle of a normative nature under primary EU law. We have provisions in the treaties that recall the principle of solidarity, although this dimension so far also in the case law of the Court of Justice seems mainly limited to the understanding of a structural principle governing the vertical relation between the Union and the Member State, or horizontally between the Member State itself. However, it does not seem completely improper to reflect on whether a normative value to the concept of solidarity could also be recognized with regard to horizontal solidarity between individuals. Meaning, for example, in understanding the solidarity between the citizens and migrants or asylum seekers in this dimension. I think this is particularly the case if one can consider this form of solidarity also as a projection of the principle of respect for human dignity, which opens the Charter of Fundamental Rights and appears also in Article 2 of the Treaty on the European Union, close by to the reference to solidarity, which is intended in that provision of the treaty, not just as a structural principle, but also as a form of, the way in which the European Union should stay towards the external part, the external and third countries, and also the people of the countries. Against this consideration, therefore, in my view, with regard to our topic of today, two questions arise. The first is how European criminal law, the facilitator package, therefore, should relate to the value of solidarity, understood in this way? And the second, more generally, can European criminal law, considering specifically the facilitator's package, sanction or tolerate the sanctioning of a morally justified action, meaning an action that is aimed at safeguarding the human dignity of another human being? We'll try, therefore, to disentangle this key issue today with Francesca Cancellaro and Stefano Zirulia. But first, allow me to spend a few words about our two speakers to introduce themselves. Francesca Cancellaro is a lawyer specialized in criminal law and fundamental rights, and for several years now has been working both as a lawyer and as a consultant on cases involving NGOs engaged in search and rescue at sea. She's a partner lawyer at the European Center for Constitutional and Human Rights, and she has also an academic background. She holds a PhD from the University of Bologna, where she defended a thesis on the arbitrary detention of migrants at Italian borders. And she has been also a postdoctoral researcher at the University of Roma III in Tuscia. Francesca today will present us with a perspective on the criminalization of humanitarian assistance from the field. Thank you, Francesca. Stefano Zirulia is assistant professor at the Department of Law of the Università degli Studi di Milano, where he teaches criminal law and European criminal law, environmental criminal law, and human rights. He has worked also for many years on issues of migration criminal law, and has also experience in litigation before supranational courts. He was indeed the defense counsel for one of the applicants in the well-known Califia case, Califia versus Italy, before the ECHR in 2016. Most recently, he co-edited with Professor Gianluigi Gatta and Balsami Smitzi-Legas the volume Controlling Immigration Through Criminal Law, European Comparative Perspective on Crimmigration. The volume has been published in January 2021 with Art Publishing, and in this volume, Stefano wrote a contribution entitled "Is That a Smuggler? The Blurring Line Between Facilitating Illegal Migration and Providing Humanitarian Assistance at the European Border." His presentation will introduce us with the perspective on the normative tensions of the European framework on facilitation of irregular migration, with regard indeed to the topic of humanitarian and solidary action. With this, I'm concluding my introduction, and I'm glad to give the floor to Francesca for the first presentation of today. Thank you, Francesca. The floor is yours.
Good evening. Thanks, ULB, for organizing this seminar, and thanks, Angelo, for your kind invitation. It is a real pleasure to be here today. In the next 20 minutes, more or less, I'll try to answer the tricky and the provocative question, who is a smuggler? And let's start by saying that according to the Italian law that adopted in the national legal framework, the European Facilitators Package of 2002, a smuggler is someone who affirms acts to procure legal entry into Italy or another European state. However, it is not a crime to provide rescue or assistance to foreigners already present in Italy. As you can see, the financial purpose, the financial gain, is not an element of the offense, and Italy provides specific humanitarian exemption, the so-called humanitarian clause, that applies only when facilitated migrant is already in Italy. This means that cases of facilitating illegal entry are excluded. And as we'll see, causes of justification such as state of necessity and duty to rescue established by the legal framework do not cover all relevant situations. And even when they should apply, they leave too much discretion to the judiciary. Moreover, the very same law provides very high penalties, very high sanctions. In fact, the smuggler is punished with imprisonment from 5 to 15 years and with a fine of 15,000 for each illegal entry, which means for every person helped, in some circumstances that actually covered almost every case. For example, when the act concerned the illegal entry or stay in the territory of 5 or more persons, which is the case of NGOs usually, or when the offense is committed by 3 or more persons in complicity. Again, this is another case that applied with NGOs, or by using international transport services or false documents, and this happens almost always in these cases. Moreover, if more than one of these hypotheses apply at the same time, the penalty is increased up to 20 years of imprisonment. As you can see, such a kind of definition and these sanctions are improper to grab the phenomenon of smuggling, and according to my experience, this law causes many different problems. In fact, the obligation to punish everyone who assists a person to enter or transit across the territory of a member state in breach of the law, even without a financial purpose and without a proper specific humanitarian exemption, brings to consider a crime many kinds of solidarity with undocumented migrants and asylum seekers. I am talking about, for example, sea rescue activities, assistance provided during secondary movements, for example, Alps crossing between France or the Slovenian border, but also, the altruistic help. For example, I'm talking about the Riace case, but also solidarity among migrants. First, I see a lack of understanding of the complexity of the social phenomena related to smuggling. And actually, in my opinion, this is one of the most striking examples of inappropriate legal responses to the complexity of social phenomena. Secondly, we have in practice another criminalization with very heavy penalties, as I said, of conduct indeed driven by humanitarian aims, or at least without financial gain, as I have already mentioned. And this other criminalization involves migrants, who in many cases are asylum seekers who have faced the journey themselves or who have helped friends or relatives, and also human rights defenders and NGOs involved in the protection of fundamental rights. Some cases show clearly the struggle between the protection of borders and the protection of fundamental rights, and perhaps one of the best known cases of criminalization of solidarity, both in Italy but I think in Europe, is the Rackete case. A case I worked on because the NGO Sea-Watch and her captain and her shipmaster are represented by the Gamberini law firm where I work. And this case was about the first entry into the port of Lampedusa conducted by the shipmaster of Sea-Watch 3, Carola Rackete, during a search and rescue operation in June 2019, sorry. The captain was immediately arrested for the offense of resisting or obstructing a public officer and resisting a warship. And for colliding with an Italian patrol boat while docking in port. She was also investigated for facilitating illegal immigration. At the beginning of 2020, the Italian Court of Legitimacy, which is the Court of Cassazione, stated that the racket arrest was unlawful and ruled some important principles in this matter. It was the very first time that Italian Supreme Court of Legitimacy was directly involved in the issue of the criminalization of rescue activity at sea. In that case, judges recognized that all rescue operations at sea, up to the landing in a safe port, the so-called place of safety, are not punishable because they are covered by the legal justification of fulfilling a duty to rescue that comes from the international conventions on the law of the sea. And in particular, the court ruled that only landing on the land concludes the rescue, and therefore all rescue operations that possibly violate a criminal law are not punishable. As I mentioned, the court ruled on the arrest of Carola, but as I said, she is also under investigation for facilitating illegal immigration, and some of the arguments developed by the court venture extend to such conduct. Both investigations are are formally still open, but we are waiting the formal closure of the investigation. Well, at that point, I had hoped that thanks to this case law, the situation would have been better for human rights offenders and their organization, but actually I have to admit that I was wrong. Now I have the impression, the feeling that we won a very important battle in the Rakete case, but we did not win the war against the criminalization of solidarity, not even the solidarity at sea. What is the current panorama, let's say? With respect to migrants and asylum seekers, nothing has changed. They are the ones who suffer the most for the consequences of the smuggling over criminalization, both with respect to preventive measures, I'm talking about the deprivation of liberty, and to the heavy sentences applied to those cases. Usually they are convicted with high sanctions. And with regard to NGO members and activities, criminal investigations for smuggling have continued, as well as the interruption of their humanitarian activities, even though there have been no convictions so far. In the case of sea rescue, which is the one I know best, there are many ways to interrupt or to affect activities with criminal and administrative seizures of boats, with long investigations, etc. Moreover, the bad narratives have continued, and the climate of suspicion also affects the legal defense of these defendants. As an example, I would like to talk to you about the case I'm dealing with at the moment that I found very interesting from this point of view. I'm one of the lawyers who represent the Juventa crew in the criminal proceeding before the Tribunale di Trapani, the Tribunal of Trapani. This proceeding involves also the other NGOs. They are Save the Children International, Doctors Without Borders, Médecins Sans Frontières, and some of their crew members. Well, some weeks ago, we received the notification of the end of investigation, and finally, we had a full discovery of the case file after 4 years of investigations. The prosecutor officially charged 21 individuals. Among these defendants, there are some members of the Juventa crew who were accused of facilitating illegal immigration. And please consider that the Juventa vessel owned by the German NGO Modérateur has been under seizure since 2017 because of this investigation. Well, more in general, the 21 defendants are charged with many offenses, actually, besides facilitating illegal immigration, also for other offenses consist in false communication to the Italian authorities and other offenses related to the Italian Naval Code. Except UN-rated, NGOs are themselves also charged with some offenses, probably because their ships sailed under the Italian flag, so there is a jurisdiction issue also. But even if I can say from now that we'll prove in next years that Juventa conduct was lawful, you can imagine how such a kind of investigation can impact on the life of people involved, on public resources, on the bad narratives, on the end of SAR operations. The vessels, the Juventa vessels, lies idle, almost destroyed in the port of Trapani. This huge investigation is part of, let's say, a new wave of criminalization of solidarity, which is taking place at the moment in Italy, and Angelo already mentioned some cases. And I'm telling you this, I confirm this, because there are other investigations that emerge in the very same days. I have to say that governments have changed in Italy, as you probably know. New legal provisions were introduced, but such a kind of criminalization against humanitarian assistance has never stopped. Therefore, there's a need, in my view, to find solutions. This is the trickiest part. And first, there's a need of legislative reform at the European and at national level. However, reforms do not seem to be on the agenda of member states and the European institutions. And if you consider the European Commission communication on a new pact on migration and asylum that Angelo has already mentioned, we can see why we are not probably ready for this step. So a second solution could be the strategic litigation before the national and the European courts that can lead to both social and legal progress, as well as law reforms, why not? That is why I'd like to share with you my first attempt to bring the smuggling issue before the Italian Constitutional Court, in order to challenge the lawfulness of the Italian smuggling discipline, at least. Some months ago, acting as a lawyer, I have requested to refer a case to the Constitutional Court because it has the power to declare a provision or even a part of it unconstitutional, neutralizing it with erga omnes effect. I chose a case that seemed to me less, let's say, political and far from the interest of the media. And moreover, I found that it was a perfect case to show the paradoxes of such a kind of law. The case concerned a Congolese woman who arrived at Bologna airport in 2019, bringing with her two children, one of whom is her daughter. They all had false documents and applied for asylum in Italy. The woman was immediately arrested as a preventive measure on charges of facilitating irregular immigration again, and currently faces a sentence. She faces a sentence of up to 15 years of imprisonment under Article 12, Paragraph 3 of the Italian Consolidated Immigration Law. I argued that such a penalty is in breach of the principle of proportionality of the sanctions and in breach of the principle of equality and rationality. The Criminal Court of Bologna accepted this argument, and therefore it referred the case to the Constitutional Court that will rule on the issue within the next month. Well, unfortunately, the tribunal did not accept other arguments that I brought to its attention. Maybe later there will be time to discuss them, but I hope that also Stefano will approach other profiles of contrast with the Constitution and with the European Charter of Fundamental Rights. Anyway, this will be the first case in Italy where the Constitutional Court will deal with the so-called crime of solidarity, and the second case in Europe after the French Conseil Constitutionnel. I think this could be a good case to establish principle erga omnes that could apply in any case of smuggling, even the ones that involve NGO activities, both at sea and on the mainland. Well, it was my first attempt in this, so obviously there is still a long way to go, but it seems to me like a first step in the right direction to opposing such a kind of overcriminalization and for enhancing the protection of fundamental rights of migrants, asylum seekers, and of those who assist them. So I conclude thanking you for your kind attention.
Thank you very much, Francesca, for the very nice presentation. We can, if you want, we can pass immediately to the presentation of Stefano and then open the floor for the question and answers. If Stefano is ready, we will be very happy to follow up on this, let's say, European legal framework and on the extensions, and then we will have a discussion. We'll open a discussion with the participants. Stefano, therefore, thank you very much. The floor is yours.
Thank you. Thank you, Angelo. Good evening, everybody. And yes, thank you for the kind introduction before, and many thanks to the Centre de droit européen de l'Université Libre de Bruxelles for this very inspiring event and for the opportunity to present here such a prestigious event, seminar. So I have divided my presentation in two parts. First, I would like to briefly address the definition of smuggling of migrants under EU secondary legislation, which is a way to try to answer the question who is a smuggler, although under the law, so it's not like it's still a questionable answer, of course. And we also try to explain why, in my opinion, this definition is definitely too broad. Secondly, I would like to turn to possible remedies for this against this overreaching definition of smuggling of migrants, mainly under the EU Charter of Fundamental Rights. So I've prepared some slides, which I will now share with you. Just 1 second. There. Okay. So I hope you can see the presentation, otherwise just let me know, of course. So let's start with the first point, the notion, the definition of smuggling of migrants under EU law. Well, the fight against migrant smuggling, as we all know, has become an urgent matter in recent years, but EU secondary legislation on the subject is quite an old one, as you can see. This legislation dates back to the beginning of the century, and it is commonly known as the facilitators package. It is a combination between a directive 2002/90, and a framework decision of 2002 as well, where the directive defines the legal conduct of facilitating illegal immigration, and the framework decision imposes upon member states the obligation to criminalize, so to provide criminal penalties for those conduct. So this is the typical double text approach which was used to impose obligation to criminalize when the union was structured as in pillars, in 3 different pillars. So the result of this combination, of the combination between these 2 instruments, is that, as you can read, member states shall provide international laws for criminal penalties in respect to anyone who assists the person who is not a national of a member state, so a foreigner, to enter or transit across the territory of that member state in breach of immigration laws. 2 important elements must be stressed. The first one is that unlike the definition of smuggling that we find in international law, namely under the UN protocol attached to the UN Convention on the Fight Against Transnational Crime, so unlike that definition, here under the facilitators package, the financial gain purpose is not an element of the offense. And the second one is that according to the directive, member states are free to provide or not a specific humanitarian clause, so some kind of specific humanitarian exemption in order to prevent criminalization of so-called humanitarian smuggling. The collateral effect, the side effect of these provisions is, of course, the criminalization of solidarity with undocumented migrants and asylum seekers, because it happened because, on the one hand, member states are not called to limit the punishability to those conduct which are performed for a financial gain purpose, and on the other hand, they are not called to provide humanitarian exemptions. Some states do provide humanitarian exemptions, but those are many of those are very limited in their scope. This is the example of Italy, for instance. In Italy, we do have a humanitarian exemption, humanitarian clause, but its scope is limited to assistance provided to migrants who are already on the national territory. So it's the case where someone is helping someone who is in need of help in Italy already. But this exemption does not apply to conduct which consists in helping migrants to cross borders. It's the same as in France. And in France, it is a situation, it's precisely the situation that has resulted after the Conseil Constitutionnel decision, which Angelo recalled before. So I say the collateral effect is the criminalization, or at least the risk of criminalization of solidarity. And there are several examples of this criminalization, which Francesca has already mentioned, such as sea rescue activities, assistance provided during secondary movements, which can be very dangerous as well, such as Alp crossing between Italy and France. Humanitarian help to asylum seekers, which is also another frequent situation, considered the lack and the insufficiency of humanitarian corridors for asylum seekers. And even, last but not least, because there is an important case law on this matter in Italy, a relevant case law, mutual assistance between migrants, such as in case of boat drivers. Boat drivers are often just migrants among migrants who are asked to, or sometimes forced to drive the boat. The problem is that, as Francesca already mentioned, common justifications such as necessity and duty to rescue sometimes help with preventing the criminalization of this conduct, but sometimes not. It's not always the case that the assistance is provided to someone who is in distress, who is in a situation of danger, and this has to be proved. So the problem is also that before, even when a common justification finally apply, but still a criminal trial needs to be celebrated in order to assess this justification, and of course the fact itself of being prosecuted can produce some kind of chilling effect on potential rescuers, on future solidarity. So the fact itself that it is possible to prosecute someone is a problem, even when eventually a common justification will apply. Well, in order to prevent this overcriminalization, legal scholarship has already widely investigated different solutions at the legislation level. So providing a profit-making purpose, an unfair financial gain element, a bar for prosecution in cases of humanitarian assistance, but it's very unlikely, as Francesca mentioned, that this reform will be enacted soon. If we looked at the communication that Francesca mentioned, I've reported the relevant argument. The communication, the Commission only says that reflection is ongoing about the modernization of the facilitator package, and rescue people in distress at sea cannot be criminalized. So a very limited, just some kind of instructions, of recommendations limited to the sea, and for all the rest, which is quite an important, which encompasses quite a lot of important issues, just reflection, ongoing reflections. So meanwhile, during the reflections, I think other avenues, other at least explored. The first one, which I will address in the second part of my presentation, is challenging the legitimacy of the facilitator's package itself before the EU Court of Justice. And the second one is the one that Francesca mentioned, which is challenging the legitimacy of national criminal laws implementing the facilitator's package. This is the avenue that has been already pursued in France, which has led to the ruling from the Conseil Constitutionnel, which is only partially a good ruling, because it is limited again on solidarity on the French territory. So it does not consider solidarity with regard to crossing the border, which is probably the most important issue. And very soon we will have a decision, a new ruling from the Italian Constitutional Court about our facilitating of illegal immigration offense. So I think I will have time only to deal with the first point, and which is the problem of legitimacy of the facilitator's package itself. So in order to address this, in order to make this argument, I need to refer to a judgment which apparently is far away from us, but actually it is not, in my opinion, which is the judgment from the Supreme Court of Canada, released by the Supreme Court of Canada in 2017, not 7, so sorry for the mistake in the slide, in the Apulonappa judgment of 2017. Here, the Canadian Supreme Court declared the illegitimacy of the Canadian offense of facilitating illegal immigration, which is entirely similar to the offense provided by EU law. So the fact that the offense provided by Canadian national law is the same as the one provided by EU law makes it interesting to look at the arguments developed by the Court of Canada in order to check whether there could be arguments which we can somehow import within the European Union. Well, which are the arguments? It's a long judgment, so we cannot go through all of it. But which are the main arguments? The main arguments from the Canadian court. The court stated that the purpose of the Canadian legislator was to combat the smuggling of migrants, and therefore the offense, the Canadian offense, unreasonably compresses fundamental rights of the accused person in three different situations: humanitarian aid to undocumented entrants, mutual aid amongst asylum seekers, and assistance provided to family members. So, two passages of this judgment shall be pointed out. The first one is that the court, according to the court, the offense, the Canadian offense, is applicable when the court reads the judgment, to situations which have nothing to do with smuggling, such as humanitarian help, mutual assistance between migrants, and assistance to family members. Secondly, the court found that in these situations, in these three sets of situations, the fundamental rights of the helpers, the fundamental right to personal liberty of the helpers was unreasonably compressed because the helpers faced the risk to be jailed for their conduct. And therefore, the Canadian court ruled that the offense, the Canadian offense, was overbroad and shall be read as not applicable to those offenses, to those three sets of situations. So it's a judgment which reads the Canadian provision in a restrictive way, which restricts the scope of the Canadian provision in order to fix this problem of overreaching scope that the court had highlighted. So in my opinion, this kind of reasoning by the Canadian court, as I said, could be somehow imported to Europe, and the relevant provision to this purpose would be Article 52 of the Charter of Fundamental Rights, providing the principle of proportionality when compressing fundamental rights recognized by the Charter itself. In fact, the facilitator's package does interfere with the set of fundamental rights provided by the Charter. Personal freedom of the accused accused persons face jail terms for facilitating illegal immigration. Life and physical integrity of undocumented migrants, which are threatened by the fact that rescue activities are limited. And third, the right to seek asylum, because whenever humanitarian corridors are lacking or are insufficient, of course, the help of someone to illegally cross a border and to ask for asylum when arrived to destination is necessary. So proportionality, of course, is a very vague concept, but the Court of Justice has provided a definition of this concept, as defined in which sense proportionality limits the power of the European institutions. And namely, the court has stated that according to that principle, the act of the institutions be appropriate for attaining the legitimate objectives pursued by the legislation at issue, and do not exceed the limits of what is appropriate and necessary in order to achieve those objectives. So proportionality means, on the one hand, to select legitimate objectives, and on the other hand, not to exceed the limits of what is appropriate and necessary in order to achieve them. Which means if in order to achieve those objectives, some fundamental rights shall be limited, this can be done provided that the limitation is appropriate and necessary in order to achieve those objectives. So let's try to see how this concept of proportionality can be applied to our context. And so first of all, we have to identify the legitimate objectives pursued by the facilitators package. And on the other hand, we have to check whether the interference with the fundamental rights produced by this legislation is appropriate and necessary to achieve those objectives. So let's first argue that the objective of the facilitators package is fighting against smuggling of migrants. Well, if this is the objective pursued by the European legislator, then, just as the Canadian court argued, the current obligation to criminalize any conduct of facilitating, not only conduct of facilitating for a financial gain purpose, but any conduct of facilitating, is overbroad, as it applies also to people who have nothing to do with the black market of immigration. So here, if we assume that fight against migrant smuggling is the scope, is the purpose, the objective of the facilitators package, then we have an issue of proportionality in terms of excessive scope, overreaching scope of the legislation, which has also some further side effects. Let's think about the waste of resources in prosecuting humanitarian smuggling. So here we could think to build an argument based on the effet utile of the directive, which, in my opinion, could be undermined but by such a broad definition. But let's also imagine that the objective was not, the objective of the facilitators package is not fighting against migrant smuggling, but it is broader, and it is the protection of borders. Well, even in this case, I would say that we have a proportionality issue. We have a problem with proportionality because such a broad obligation to criminalize interferes with fundamental rights which are higher ranking if compared to the borders. And these rights are the one I mentioned before: life of migrants, physical integrity of migrants, right to seek asylum. So here we would have, if the objective is protection of border, we would have an issue of proportionality in terms of hierarchy of interests at stake and improper balance between these interests. My conclusion on this point is that the validity of the facilitators package could be challenged before the European Court of Justice, by referring under Article 267 of the Treaty on the Functioning of the European Union, referring a question of validity, a preliminary ruling for validity, to the court, arguing that the principle of proportionality precludes a secondary legislation, such as the one provided by the facilitators package, which imposes upon member states the obligation to criminalize any kind of facilitating illegal immigration, even where no financial gain is pursued, and at the same time, it does not make it mandatory to provide a humanitarian clause, a humanitarian exemption beside that criminalization. So that let's say the fact that these two conditions are simultaneously existing under EU secondary legislation make it illegitimate, in my opinion, under the proportionality principle. So I have covered my 20 minutes, so I'm not going to address, at least not in my presentation, the second point with regard to the proportionality of national legislation penalties, but maybe there will be room for that during the discussion. So thank you very much for your attention.
Thank you very much, Stefano. Very clear and very interesting. I think you provided us really with some very serious arguments and very serious reflection on the problem surrounding the facilitators package. I would like to open the floor for questions from participants, and I will be happy to give you the floor. Chloe, raise her hands. Please, Chloe.
Thank you, Angelo, and thank you, Francesca and Stefano, for these very interesting presentations. I would have two questions, one for Rich. The first one is for Francesca. I was wondering if in your practice or in the cases you have heard about, you mentioned a lot of cases involving NGOs, but I was wondering if you had cases where, for instance, persons were prosecuted when they assisted persons who were family members or persons with whom they had a romantic relationship, not necessarily to enter into Italy or to enter the country, but maybe to reside in the country. I mean, I'm from France, and in France there is a long-standing line of cases with such situations. And that's why I was interested to know if it's similar in Italy. And then to Stefano, I had, well, one and two questions. The first one is I was very intrigued by your idea to bring the facilitator package before the Court of Justice. And I was wondering whether you think there is a chance that the national judge will make such a request for a permanent reference, and whether the court itself would be at ease to potentially annul or at least declare the facilitator package incompatible with EU primary law. And the second question is also linked to what you mentioned, the fact that the EU standards are not in conformity with international standards, and whether you think that there is another avenue, which is to go not like to the Court of Justice, but maybe to try to find a way to enforce better the international standards. Thank you, and I won't abuse longer, and I'm now stopping to hear your answers.
May I start to answer the Okay, answering. Okay, thank you for your question. Yes, as I have probably mentioned, such a kind of offense affect both individuals and NGOs, which means that, of course, even there are many cases related to families, to friends, or simply cases related to people who approach the journey together. And so they are very frequent, very common, and they suffer the most the consequences of this situation. One of the most well-known case is about the matter of Riace. I don't know if you have already heard about it. And it was a case in which this matter of the very south of Italy decided to shape a system of solidarity, and in that context he helped his partner, and the brother of her partner, in order to guarantee an entry. So this is probably the most relevant case, but of course, when we talk about NGOs criminalization, we have to bear in mind that criminal liability is always personal. Then, of course, there is also the effect of the criminalization of NGOs, but first of all, individuals are responsible for their conduct. This means that this doesn't mean that NGOs are not directly affected by offenses, by such kind of offense, because they suffer, they are involved in offenses that are related with smuggling. Sorry, this was the last case probably I presented, the Juventa case, and also the Médecins Sans Frontières and Save the Children ones. In that case, NGOs were directly defendants, let's say, because there is a law in Italy that allowed such a kind of criminalization for some offenses. So I don't know if I answered your question, but of course, also if you consider the case that I referred to the Constitutional Court, is about a woman who broke with her 2 kids. One of them was her daughter. So of course, there is also some good case law, let's say, that helps to defend, to represent these people, but it's not that obvious that they are not convicted, because if there is not such a great media attention, such an interest of organizations, and you know, if there is no solidarity of the public opinion, then they risk a lot. And I have many cases in mind that reflect this. This is not only theoretical, it's practical, it's a practical problem. And I would like to underline that migrants and asylum seekers are the ones that risk the most. So there is a gap between the fundamental rights of defendants as well, also in this field.
Thank you for your questions, both very interesting and thought-provoking. With regard to the reference for a preliminary ruling to the Court of Justice on the validity of the package, well, I'm not sure this is the right political moment in the EU for such an initiative, but at the same time, I think that it is quite clear that this legislation is not sustainable under the proportionality principle. This legislation has been introduced 20 years ago. The situation has changed. This problem of the criminalization of humanitarian assistance is now undeniable in front of everybody's eyes. So it would be at the same time hard for the court to deny that the issue is there. And we can also remember that sometimes the court has somehow given surprising ruling under the perspective of the protection of fundamental rights. So let's remember Eldridi in 2011. 2011, Eldridi was an attempt to change the Italian legislation, which at that time brought to jail for years thousands of migrants, and it worked. And it worked because there was an issue of fundamental rights, of course, but the court stressed very much the argument of effet utile, not that much the one of fundamental rights. This was smart because, of course, in this way, the court did not had to argue that member states somehow were acting in breach of fundamental rights, and the court was capable to build this argument, turning it in the perspective of efficiency to reach. You cannot detain migrants because this would undermine the return program. Well, as I have tried to argue, this could also be somehow an argument that one could try to shape under the facilitators package, because I think that wasting resources for prosecuting people who help other people is pointless. And this could be, and these resources could be instead used for prosecuting real smugglers. And real smugglers are those who make it for money. And here the argument, the element of financial gain, so the argument according to which the financial gain should be there, comes back. So, well, I'm not fully optimist, because at this time of immigration crisis and so on, the court could have some kind of self-restraint before judging on the legitimacy of the facilitators package, but still it's possible. Of course, what we hoped from the Italian perspective, when Francesca tried to refer the court to the Constitutional Court, was also to stimulate the judge, the criminal court, to provide to the Constitutional Court arguments for referring the question to the Court of Justice, because we have seen in recent years. Let's mention, for instance, the Taricco case. We have seen that the dialogue between these two higher courts works very well. So probably it would be wiser to let the Constitutional Court depart the role, the task of referring the issue and of shaping correctly the issue to the Court of Justice. And maybe the Court of Justice will also have be more sensitive to listening carefully an argument coming from national court. Unfortunately, in this case, the criminal court has referred to the Constitutional Court only a small part of the argument that Francesca proposed, and these are the arguments strictly related to the proportionality of the penalty. So the argument was that this penalty is too high when you deal with an asylum seeker coming to Italy with minors. So the scope of this referral is not as wide as it would have been necessary to present to refer to the Court of Justice the whole set of issues that I have presented, but still there is a possibility that the Constitutional Court will ask the opinion of the Court of Justice. With regard to your second question, well, yes, I confirm that the European notion, the European definition of smuggling is wider, very much wider than the international law definition, and it's not a definition of smuggling. The definition under the European law, it's a definition of facilitating illegal immigration, which is aiding and abetting illegal immigration. Is something wider and different from smuggling. I'm not sure that one can make the argument that the European secondary legislation is not compatible with international law, because international law provides a minimum standard for states to criminalize smuggling. It says at least you must criminalize those who help migrants for money, but it does not prevent the criminalization of further conducts, such as those which help migrants out of financial gain. I'm afraid that, therefore, international law cannot be used in this way. But at the same time, I think your argument can be used in arguing that smuggling and the severe sanctions, the criminalization of smuggling is something different, is criminologically something different from what has been done at the European level. We have introduced this confusion between smuggling and aiding and abetting illegal immigration, which is the source of all problems. I think that, and I wrote that aiding and abetting illegal immigration, if punished, should be punished with the same penalties provided for illegal migrants. So it's a matter of proportionality. It's just the same thing. The person who is crossing the border and the person who is helping to cross the border. If I under criminal law, in general terms, if I commit robbery or a theft, the person who helps me is punished for the same crime, not for a different one. So I think that as long as member states punished or sanction illegal immigration under administrative law, this should be the same sanction should apply to those who aid and abet them. If they provide some kind of misdemeanor, such as Italy, we have a misdemeanor for illegal immigration, then the same sanction should apply for aiders and abettors. Smuggling is something different. That should be that is the next step, I think, of the policy at the EU level and of the jurisdiction as well. I hope I have answered to your very interesting questions.
Yeah, no, thanks a lot to both of you. I stop now.
Thank you, Stefano. Thank you, Francesca. Unless there are questions from the floor, I would have a question. One is Francesca, because you made reference to narratives, and in this regard, I would like to ask you, from the field, to what extent certain narratives, and I'm thinking such as defining the presence of NGOs as a kind of pull factor on one end, or, for example, distinguishing between humanitarian motives when they are mixed with some motives that can be considered militant motives. To what extent this kind of narratives actually impact on the concrete understanding that then judges, policemen, have of what is considered humanitarian in some way on the ground. So if in your experience you have faced some kind of impact of this kind of narrative that have been on for years, especially the pull factor, and it's was particularly striking because it was coming also from a Frontex report at the beginning, and this can have an impact and has an impact on the floor on how actually then anti-smuggling legislation is enforced.
Well, thanks, Angelo, for your question, which is quite hard to answer because it's a very complex issue, and you know, I have the impression that in this field, narratives in general play a fundamental role. We have experimented their role in last years. It was very clear since 2017 that there was a change in the general opinion, and politicians as well have changed their words, and judiciary start to be involved also in the political process. And of course, we have always to bear in mind that migration is a highly political matter, always, which means that it's hard to try to balance and to be fair when we talk about legal solutions, because of course I can say that there was a use and maybe an abuse of judiciary power in order to pursue also political gains and so on. This is something that of course has a huge impact. As I tried to explain in my presentation, I also sometimes find it difficult to represent individuals that are involved in these cases, because first of all, you have to understand how to explain from a juridical, legal point of view the situation before, and before this you have to understand that there is a huge media impact of the case, and there will be a narrative that could impact and affect the case. So there is a question of defamation as well, that many people involved in these cases have to suffer. And you know, it's tricky, and we have many examples of this. And of course, this is a key issue. And I also have the impression that this is part of the banalization of the phenomena related with smuggling. Because of course, if you consider only all these activities from a legal point of view, we risk to lose the core of these activities, and to lose which is the practice, the real practice on the field. And I had many interesting discussions with criminologists and sociologists that are scholars that are expert in this field. And this is, if you talk with them, you can feel the huge gap that there will be from the narrative and the reality and the judiciary representation. It's very interesting to read all judiciary measures in order to understand which is the difference in the approaches. It's a really, it's very interesting to analyze these measures, because you can find some part of the influx of the narratives there. So I have the impression that could be a great tool to understand the situation and the impact of narratives. I don't know if I answer your question, but...
Yes, thank you. There is any... Thank you, Amy.
Hi, yeah, thank you. I just have a quick follow-up on Stefano's emphasis on the Commission's ongoing reflection in the Migration Pact. And I was just wondering what you think the next steps might be from the Commission, or whether it is that they are perhaps waiting to gauge or to measure the response of member states, which then might also touch upon the second part of your presentation that you didn't get round to. So really, do you think it's something that's going to come from the Commission, or is it really something that is going to be bottom up, as it were?
Thank you for your question. I don't know. I mean, it's very hard to foresee what will happen in this respect, because I have the impression that now, well, the strategy of the Commission has changed in few years. The communication of 2017, in the communication of 2017, the strategy was denying the problem. So we read, no, there are no, well, of course, this notion of facilitating could apply to humanitarian assistance, but we have no information about that from member state. We don't think it's going on, and this was denying the problem. And a few years later, as we have seen in this communication, the Commission admits that the problem is there, and that reflections are ongoing. So at least this is a step forward, and so we may think that during the next years, further steps will be realized. The main obstacles that the Commission, because in the communication of 2017, the Commission said, well, the problem is not there because there are no, there is no criminalization, and on the other hand, we cannot we cannot provide the financial gain element within the definition of aiding and abetting, because this would undermine investigations and prosecution. Because if we provide a financial gain element, then this means that national prosecutors will have to investigate about money flows every time, and investigating about money flows which happened abroad, out of the European Union, in states such as Turkey or North African states and so on, would be extremely hard, and this would completely undermine our capacity of investigation. Well, this argument, in my opinion, was not a strong one, because the financial gain element is not about the actus reus, is about the mens rea, speaking about criminal offense elements. And when you think about, when you speak about mens rea, you don't need the material, you don't need the evidence of something material, you just need the evidence of a purpose. And this can be provided not only by the money flows, but also by witnesses or by other elements, such as the fact that someone systematically helps migrants with crossing borders and so on. So there are other avenues for evidence. So let's say overcoming this obstacle, which was weak, could be another step forward, like arguing that this would not undermine the investigations on the real networks of smugglers. This could also help in moving forward. But besides the legal argument, I think this is very much a political issue. It's too much a political issue. And I'm afraid that the Commission fears that modifying the facilitators package will give some kind of message, will give what states could consider a wrong message, which is from now on, helping migrants is not a crime anymore. This message of decriminalization, I think, is it's something that the Commission wants to avoid, because states want to avoid. So, of course, the Commission has a great deal of independence from states, but still, it's not a full independence, as we know. So, let's say legal arguments can be overcome. Political arguments, I don't know. That's why I would keep insisting on bottom-up approach, as you said. So litigation.
Thank you.
Thank you very much, Stefano. Very clear and extremely thoughtful. I think we had a very interesting discussion, and yes, I agree with your conclusion that indeed the topic is a key topic that will need to be addressed, and we will expect to be addressed through litigation, probably instead with then expecting legal reform or at least an input at the moment from the Commission, because as I was mentioning, this case against Hungary, which sends a signal in some way, is another avenue that the Commission is trying to take through litigation and without referring to the facilitators package, but in a topic that is very, very close. So there is, let's say, some kind of prudence on legislative initiatives, but there is some awareness that is growing that the problem is there. We will see what will happen with this case, and we will see if the cases that Francesca is litigating in Italy will get this way through Luxembourg in the end, and that will be extremely interesting if it happens. I would like to thank all the participants, and I think we reached our time of 19:30. It was very, very great to have to discuss with you, and I'm very happy to invite you and maybe continue discussing with you again on this topic. I would like to thank you very much. I would like to thank Ilaria, who helped greatly on the organization of this event, and I hope we will have further occasions to discuss in the future and see what will be the developments and on our topic, and if we will manage to understand who is a smuggler actually. Good evening to everyone, and thank you again. Goodbye.
Bye, thank you.